Kennedy Graham.
Thank you, Mr. Speaker. I actually do have the light-hearted privilege of serving on that committee, and I just can't wait to look at this bill in detail. Mr. Speaker, the stated purpose of the bill is to simplify criminal procedure in New Zealand. It is described, at least by the Minister, as comprising the most comprehensive overhaul of the New Zealand criminal justice system in half a century. Specifically, it seeks to achieve 5 goals, we are told. First, to reduce unnecessary delay and efficiency in court processes. We're told it seeks to avoid unnecessary stress to victims and others involved in the criminal process, to eliminate unnecessary complexity in criminal legislation, reduce the shortcomings from piecemeal amendments and facilitate new technology in the courts. Simplifying those criminal procedures, the Minister says, will result in 43,000 fewer court events each year, freeing up to 16,000 court sitting hours. It will save up to $24 million over 5 years, averaging $5 million per annum. In short, the legislation will address excessive delay, excessive complexity, excessive cost, and outdated legislation. So we are told. On face value, the Green Party is disposed to support the overall objective and the 5 stated goals. Who would not, to the extent the problems are valid? So the next question has to be, is there any downside to achieving those goals? And if so, is that downside prohibitive such that support is unacceptable? So let us analyse the bill, which runs to 526 pages, which our colleague Mr. Bridges has not read. Let me take this opportunity to commend the Minister for his energy and his commitment to criminal law reform. It has taken 2 years, more or less, of his time, and I know that he is sincere in his efforts. But such commendation does not persuade us in itself necessarily to support the product we have before us. The Green Party will need to be satisfied that the achievements of the bill outweigh any costs it may contain, costs in terms of civil and political rights that might be forfeited. Mr. Speaker, the bill seeks to implement 7 innovations. We simply have not had sufficient time to address them all thoroughly. And on that, I want to make a point, sir. I respectfully suggest that it is not good enough on the part of the government to submit a bill of 526 pages and expect it to be dealt with, given due justice, the following week. It was introduced on the 15th of November. If we add to those 526 pages the 20 pages in the fact sheets, the 34 pages of the Attorney General's reports, and the 33 pages of the regulatory impact statement, we have 613 pages to get through that are complex within 6 working days. And that is no way to run a democracy, even on first reading. It is enough to present, for the moment, an identification of our principal concerns and indicate that we look forward to exploring them in committee. First, there's the election of jury trial. This concerns the first set of proposals outlined in the bill, namely the categorisation of offences. The stated aim is to categorise criminal offences in a more simplified way. There are to be 4 categories of offences. First, those not punishable by prison can be tried by a district court judge, community magistrate or a JP. Second, those with prison sentences up to 3 years would be tried by a district court judge, one of the controversial issues. And third, for those with prison sentences over 3 years, the defendant can elect a jury trial. And finally, some in that third category will automatically be tried in the High Court by a jury. These are cases of high public or symbolic importance, such as murder, or fairness or impartiality of one judge adjudicating might be in question, such as judicial bribery. The difference here, Mr. Speaker, is that rather than 3 years for the second category, the current situation in law is 3 months. But clauses 6 and 9 of the bill, as drafted, and associated clauses, will result in this being extended to 3 years. We recognise that, as Sir Geoffrey Palmer said when he proposed the shorter term of 3 months, there is nothing sacrosanct about 3 months, and that Canada has 5 years for this category of offences, and some Australian states vary from 2 years to 5 years as well. Nonetheless, we query whether the longer period will result in any efficiencies in the administration of justice, as seems to be claimed, and we query whether there is any other reason for extending the time period. So I put it to the Minister that some people, perhaps all people, including the Minister himself, might feel more vulnerable if a sole judge were granted the power of prison sentence for up to 3 years rather than 3 months. Let us have statistics for the Select Committee on the number of people who have been sentenced to prison terms ranging between 3 months and 3 years, and then we can analyse the situation in the committee. Second concern, the right to be present. What we have is here, the second concern is about the right of the defendant to be present at a criminal trial. As currently drafted, the bill violates the New Zealand Bill of Rights Act, section 25, namely the right to be present at the trial and to present a defence. Section 128(2)(b) of the bill states, quote, "If the court is not satisfied that the defendant has a reasonable excuse for his or her non-attendance and the prosecutor is ready to proceed, the court must proceed with the hearing in the absence of the defendant," noted by at least one colleague, Charles Chauvel. So this remains a concern for us. What might be a reasonable excuse in the view of a defendant might not be so in the view of a judge. This is a clear derogation of an existing right. It is one thing for a defendant to waive one's right to be present. It is quite another for a judge to pronounce that the defendant lacked a reasonable excuse. Whether the issue can be resolved in committee remains to be seen, but let us hope so. Mr. Speaker, there are, of course, other issues the bill raises as well. I invite the Minister or any of his national colleagues who are yet to speak in this first reading to address the following. The onus of proof issue. There is the question of the reverse onus of proof that is worrying many practitioners in the legal profession. That is to say, the plans to shift the burden of proof to defendants in specific fishery and civil aviation offences. Defence lawyer Marie Dryberg, for example, has said that the provision was a shift away from the principle of an accused right to silence and was, quote, "a complete turnabout on the burden of proof." At the moment, she says, we have the right to silence, we have the presumption of innocence, and it's on the Crown to prove beyond reasonable doubt. What this will do, in my view, she says, is change the onus of proof. It means that you will have to identify your defence before a trial. Fourth, jury numbers. There is the question of the proposed reduction of jury numbers. Barrister Peter Williams, QC, said the proposed reduction in jury cases was, quote, "a whittling down of the justice process, and it will lead to the deterioration of the quality of justice in this country." As Mr. Williams has noted, the jury system is at the heart of New Zealand's democratic justice system, and to quote him, "it is a shame to cheapen it just to save money." Just by way of general comment on the bill, I note the comments of Christchurch lawyer Nigel Hampton, QC. Mr. Hampton has said that he does not think the proposed changes will solve any problems. The bill's aim, he observed, is to simplify the justice process, but with 526 pages, it's not a simple thing at all. He said the number of pre-trial conferences and out-of-court discussions had been increasing over the past 20 years. New Zealand's justice system was, quote, "clumsy and awkward." He supports having just one court for all crime cases with specialised judges, which would be far more efficient. Mr. Speaker, I advance this critique not to be oppositional for its own sake, but because, in light of our concerns, and not least in light of these comments by respected members of the legal fraternity, there are serious issues that need to be addressed before the bill passes the threshold of acceptability. At the moment, in its current form, it does not appear to do so. I challenge government members to explicitly address these concerns, stated here by the Green Party and clearly shared by leading legal figures, before this debate concludes today. Because of these concerns, we shall oppose the bill in the first reading. We look forward to seeing whether these problems can be resolved to our satisfaction in committee.